Welcome everyone to our planning board workshop, and I guess, would you like to, lead off and take the.
Sure.
I won't ask you to identify yourself.
I will identify myself. So my name is Phil Saucier, and I am one of the town attorneys from Bernstein Shore. We helped the town for many years, and my background is in planning and land use, so that's one of the concentrations I have in municipal law. So I was just asked to give so I have not been involved in this at all, just as a precursor. I'm not involved in the sort of what's different, and I did not review it for any policy decisions. Those are really up to the town in terms of like what your setbacks are going to be, what the zoning is going to be. I was just asked to kind of review it to see if I found anything from a legal perspective that to flag and to sort of offer some suggestions. So that's what I did. And I'm vaguely familiar, I shouldn't say vaguely, I am familiar with form-based codes in the sense that some of our municipal clients have adopted at least partial form-based codes. So I can point to, you probably already know this, I've studied this, Scarborough has it for the Higgins Beach District, Yarmouth has it for the Route 1 area. So there's some towns that have sort of pieced up, Portland has it for the India Street District. So there's certain, some towns have sort of tiptoed in, I guess you'd say.
Emma's got to do something.
Yeah, that's right. But they sort of adopted it for some zones, but not the entire town. This obviously would be more comprehensive. And the same issues come up every single time. And that's part, and it doesn't mean they're not solvable, but it is a little difficult. It's a little bit of a square peg in a round hole when you're trying to do form-based code planning and development review versus Maine's planning laws, which were written a long time ago. And so they don't always go together, right? And in particular, one or two places, and that's what I was going to highlight tonight.
Okay, so before we jump in,
yeah,
we have a number of people here from CPIC as well.
Great.
Right?
Okay.
And so we're doing this as a workshop. What's the best way? It probably makes sense in some places to entertain questions, right?
I'll have you take questions.
What's the best way to do it, right?
Should I focus myself around the room a little
Not
better?
necessarily.
Okay.
My question, I chair the Comprehensive Plan Implementation Committee, and I'm delighted to have other members of the committee here. I thought the consultants were going to be with us tonight. Is that not part of the?
That was my understanding as well, so there's no one in Zoom?
Did we send a link?
Yes.
Okay.
Then they confirmed this by this afternoon. They had.
Okay, well.
There you go.
And
I think they're in there.
super.
You can
Super.
promote to panelists too.
And I think at least one member of the committee is planning to attend on Zoom as well, because we're all seeing, it's
Sure.
very important.
Yeah. I think
I'll try to kind of speak around the room a little bit. Yeah.
And just trying to figure out how to best work with you and be able to answer questions out there as well. Sure. And I guess let's get everyone on, and maybe if you don't mind doing it again, very brief introduction again.
Sure. Is everyone on now?
we can also check this. We may have been able to hear all of that because the Zoom has been
That's
going. So, Kirk, Leslie, did you hear Phil's introduction, or do you need us to do that again? You're all
Yes.
good? Okay.
All right. Thank you.
So I provided it's a very brief memo, but I was going to go over the issue. What I was about to get into is one of the areas that you have to sort of take a closer look at when you're doing form-based codes are the waiver authorities. And I'll just preface it by saying, in form-based codes and in, I think, modern planning, you tend to see a desire to have waivers at the planning board level. Flexibility. That's what you hear about a lot, right? Like, let's have some flexibility for development. The thing you need to be careful about, at least under Maine law, is that if you have too much flexibility, you're going beyond your authority as a planning board. And it also can create what we call due process considerations. There are some constitutional reasons why we don't give too much authority. That goes way back to the idea behind planning, which is you don't want to have, obviously you guys would never do this, but what you want to make sure is that you don't have favoritism. You don't have, that's part of the idea behind performance standards that are clear and articulable so that people understand how to get an approval. That's the idea behind it. If I want to come to this town, I want to build something, I need to know how to do that and present some information to you to show how I meet these standards. Where you get into due process considerations, if you don't know how to do that, because it's going to be up to the whim of the planning board, right? So those are the areas that you're going to want to take a close look at, right?
So just a comment there, because I have those same concerns. Right?
Yeah.
Basically, sitting as on planning board, it'd be nice to have more flexibility.
Right.
But I worry about having too much flexibility,
Yeah.
because at least what we have to back up our decisions is the code, right? If we start taking the code over here, and I'm not saying we're changing it, but with too much flexibility, we don't have as much of a fallback,
That's right.
in my opinion.
That's right.
So I guess maybe there's a balance, but I would rather see it less waiverable. I'm not sure I'm speaking for you, but or you guys. I don't want it too waiverable for the board.
Right.
I guess
And then there's,
that's what I'm saying.
and that's even within, so there are certain realms where I'm just about to get into next, where you clearly could have waiver authority, but there's ways to prescribe that waiver authority.
Yeah.
And then areas that you are not allowed to have waiver authority. And so we want to make that clear internally. I highlighted a couple of them, but we'll want to go through a little more detail. And I have some suggestions.
Okay.
So just as an initial matter, and I have the law here laid out, but both under main statutes and the case law interpreting those statutes. What we know is that planning boards do not have the authority to waive or grant a variance for dimensional standards in zoning ordinances. Only Board of Appeals have that authority. That's outlined in main law. And again, a number of cases have talked about that. What does that mean? Dimensional standards in zoning ordinances are the kinds of things you think about, like setbacks, height, lot size. Those are dimensional standards. A zoning ordinance is something that breaks your town up into different zones and regulates them differently. So that's what a zoning ordinance is. So what planning boards can do, and this is where it gets a little confusing, you can waive standards that are non-zoning ordinance standards. You're probably familiar with that in your subdivision ordinance, for example. In subdivision ordinance, in site plan review ordinances, you typically have waiver authority as it relates to general standards that are applicable throughout the town. Road conditions, sometimes parking, buffer. You'll see some of those kinds of waivers in subdivision and site plan. They apply everywhere. It's not a zoning issue, and they're not setbacks and things like that. They're a little bit more subjective, like a buffer, for example. So you'll see that. You have to have specific authority to do that, however. So your ordinance has to give you, as the planning board, that authority. If you don't, then you can't waive anything, right? So that's the first thing you look at. And again, typically you do. I'll double check when we go back to the office, but that's what you typically have. And the same goes for submission materials, which I'm not going to spend a lot of time on tonight, but the planning boards typically have the authority to waive submission materials if you're given that authority in the ordinance. The reason why you want that sometimes, because sometimes it's just not applicable, right? You might have like a very minor amendment to something. And everyone understands that this little lot line adjustment or this little bump out of the building doesn't require a brand new traffic study, a brand new environmental assessment, things like that. So those are the reasons why you give planning boards waiver authority for submission requirements sometimes. So that's what you have the authority to do. There's one exception to that in the law, in the variance law, and that has to do with conservation subdivisions. And that's in the Board of Appeals statute, the variance statute, and it says planning boards can waive standards for that specific type of subdivision development, because the idea behind that is that they're to have some more flexibility. And that actually came out of a case. So there was a case out of Cape Elizabeth that was challenged. Planning board did that. Legislature enacted an ordinance that allowed it. So but it's very specific. That's the one time.
Do you have that example?
I could send planner some examples from other communities that allow that. They call them typically conservation subdivisions, or conservation development or open space developments.
We have
You'll see
open
that.
space, and that,
Yeah.
I just was thinking we could compare it.
Yeah, and in those cases, the idea behind that is typically here's what it would look like under traditional, but if you set aside this much open space, then the planning board can allow for various different things, right? To encourage cluster development. Cluster is the other word you say, right? cluster development. So that's a very specific thing. Other than that, you're not a zoning board, but just to give you the general rule is that only zoning boards can grant a variance from those standards. And it's very hard to get under Maine law, right? It's very hard to get. We call them an undue hardship variance. There are some other types called a practical difficulty variance, but typically an undue hardship variance, which is the standard variance. If you're going to your Board of Appeals today, I want a variance from the setback. You have to prove, among other things, 3 or 4 factors, but the hardest one to overcome is that you will not have a reasonable return on your property without the variance. And the courts have interpreted that very strictly, meaning like you really won't get any value out of it, right? In fact, there's some cases that suggest that even like you needed a variance to build a single family home, but you could have used it for recreation and a boat launch. That was enough to deny a variance. So it's a very difficult thing to do. They're granted sparingly. And the reason why is because the purpose of zoning one of the purposes of zoning is to eliminate nonconformities throughout the community. And when you're granting a variance, you're obviously allowing something outside of what you would allow typically. So that's the general background about variances, things like that. So again, you can have the authority to grant townwide standard waivers from townwide standards. And so what you'll want to do is differentiate it, I guess is my point. And I didn't obviously take the time. I didn't have a Word version of this to start moving things around and take a lot of time. But I think some of these provisions are okay from my perspective, like where the trash cans go. Right? That's not a dimensional standard per se, and you may want some flexibility on that. And things like that. But there was one in particular stood up for me, and there was a height waiver. That is clearly a type of dimensional standard, and it was only specific to that one zone. So you're not going to be able to do that. My suggestion on how to overcome that, if you still do want some flexibility, is you create a standard on how to get higher. Right, so you would say, for example, the base height is X, and that's your normal thing. However, the planning board can allow for a height to go to Y if the project shows A, B, and C. Like, there's some standards, like it doesn't impact the neighbor. I don't know, whatever you come up with. The idea being you're actually allowing up to Y in your ordinance. So it's not a variance or max. You're saying you can actually have up to Y, but it's almost like a conditional use. Think of it that way. If you want to get to Y, you have to prove A, B, C. And you can't go beyond Y. So in other words, you set the outer limits. So that's one way to do it, where if you want some flexibility, you can have a base and then you can hit this to meet the conditions.
So for that one, the 260.6, that talks about the building height, instead of saying that up to an additional story could be added to
Right.
with a waiver, there would be like a C that would dictate
That's right.
the conditions whereby the additional height.
That's right. In other words, you would say it as it's an allowed height instead of it's a variance for a waiver from the underlying height. So height is allowed to 60 feet in these following circumstances, or these standards are met. So no, it's not a waiver. You're actually saying it's allowed.
But it's actually spelled out.
It's spelled out. That's
You
right.
can still go back to that.
That's right. So that's the way you would do it. And yeah, so that's what I would say. The other way you could do it is you could, for the other types of waivers, is you could pull it out of the zone itself, right? And so make it more like site plan review. A little bit of what's happening in this I'm seeing is blending. It's a blending of site plan review and a zoning ordinance. I can understand why you'd want to do that. On the other hand, it makes it a little more difficult if you have a challenge when it gets to my desk. Because what we need to do is then we'll have to sort through, is that the allowable kind of variance or is it not allowed? There are mixed provisions. I've seen that in other towns. So for like the type that I've shown you, like lighting, I would not consider lighting to be a dimensional standard. But the way it's drafted, it's only applicable in I think it's called the downtown district or the particular district. And so then you're left having to at least argue about the fact, is that a zoning standard? Or is that more like a site plan standard, site plan review standard? So that's another, something I sort of picked up on.
We have had some discussions about not blending
Yeah.
some of that stuff together, maybe we really do want.
You have a review section, and then you have the zoning provisions.
Instead of saying all mushed in together.
Right.
And our standards separate.
Yeah.
site plan.
That makes sense. And you could pull out, like you do today, you could pull out certain standards that are just, they don't really need to be in the zone.
I have a question
Yeah.
about that. If so, if the Thompson Center zones, those have all the form-based stuff in them. And you're saying, if you want to have a waiver for height, you
Yeah.
can create these standards that you have to meet to get there.
Right. So it's not a waiver anymore.
Yeah.
It's more like,
That
it's
makes,
allowed. Yeah.
that makes total sense. And then you kind of were like, there's other things that kind of seem like site plan, you can move them in there. What I'm curious is then if they go on site plan, they cannot be zone specific, or can they?
They cannot be, right?
Yeah.
If you, in essence, you turn it into a zoning ordinance if you were to do that.
Yeah, so if something is in the site plan ordinance and it says it's only in this zone,
Right.
that is.
It's townwide. Typically site plan review ordinance are in general applicability. You do see that, and I think that's partly because you're looking to regulate in a certain way, but what you're doing, you're risking turning the entire thing into a zoning ordinance.
Yeah.
For purposes of like future, if like a challenge, I need the appeal or something. And, I think I could successfully argue, no, this is really site plan, but if you say only in the residential, it's gonna be a little difficult.
No, that's really helpful.
Because it doesn't matter what you call it, honest, at the end of the day, there's a
Yeah.
definition, they're all called land use, it's a land use ordinance, and a zoning ordinance is just a type of land use ordinance that regulates different areas of town differently. That's the way the statute reads, yeah.
So what you're saying is you're busy enough without us creating more work.
That's right, I actually haven't had to defend a lot of your decisions, which is a good thing. So, I'm pretty busy. So that's just a general guidance as you take it to the next step. So some of it will be easy to clean up. Others you may have to think about a little bit more. I just did a list of things. Some of these are house clean. While I was in there, I just said, well, that needs to be cleaned up. I might as well point that out. I know you guys are doing your own kind of house cleaning. I'll pick out a few just to bring them up and why I'm saying it. So this Webster's dictionary idea, I'm fine with that idea, which is that if you don't have a defined term, you're pointing to what you want people to look at. Dictionaries are a standard place to look if you're in a dispute about meaning, but you may want to say the addition, because inevitably it's going to change and someone's going to say which would be 16th or 18th because they use slightly different words. And you may have to think about that from time to time and update it when you're doing updates to your ordinance. This retroactivity provision in 1.40-2, retroactivity is sort of a hot topic these days. I want to see exactly what I said in here.
So
Yeah, it's on page 1-4.
before you get there though, what is the specific retroactivity law that just got passed by the city?
Sure, yeah, it's an interesting one. I was just talking about it today.
Okay.
Let me give the general because you'll have to understand it in context.
Yeah.
So the general rule of Maine is that all laws are prospective only. You can rebut that presumption by having a retroactivity clause. So if you don't have a retroactivity clause, it's going forward. And what the law says is and it's both state laws and local ordinances. It applies going forward, and it applies will not apply to pending applications. And pending applications are defined as an application that has been accepted and had a public hearing and at least one substantive review. It's something more than just a completeness review, is what the courts have said, and it may actually say on the statute, but it's something more than a completeness review. You've had to actually start to dig in on it. So it's not what some people think, oh, I got it under the door. You can still apply going forward ordinances to those applications. Now you've rebutted that with the way your wording is, right? Which is you said, just all you have to do is they're submitted in complete form. That's not technically correct. If you want to keep that, that's okay, but I would tweak this to put what the law says. Yeah.
I won't mention any of the towns. But what I have heard is, what I've been told is, because it gets into the whole issue, as you said, of when it's submitted and when you're actually done something substantive in regards to that, right?
Right.
But I believe was being at least used elsewhere.
Yeah.
Is that if an application has been submitted and fees have been counts as.
And you can do
the
that.
point where it's no longer, you can't make it retroactive. So I wanted to sort of put it in perspective on how we go through the process, see where we're at. We have staff accepts applications and so forth. We have sketch reviews, right?
Yeah.
And then after we do sketch reviews, then we go through the rest of our process is where we bring in the site plan or whatever. To the extent that you could make the case that as long as someone submitted for sketch review and paid their fees, that's where the deadline is. And that,
You could do that, and this is the place to put it if you want to do that. That's not what the state law standard is.
yeah, and that's why I want to bring it up, because how do we need to at least discuss that
Yeah.
in some of the workshops.
So we can put the language that you want in there to make sure you understand. What I would say is, and to continue on with my little treatise on retroactivity, the town, in this case, is the town meeting. If you were to pass a moratorium or a new ordinance amendment, and you, with a new standard in it, and you added a retroactivity clause, something I draft all the time, because most moratoria are designed to be retroactive. What usually happens is that something is coming to town, and a town has decided we don't have sufficient regulations to regulate that. So it's designed to be that way. And so we put a retroactivity clause, and what it says is, notwithstanding the law that says you can't, pending proceedings aren't exempt, we're going to capture everything up until approval, essentially. And you're allowed to do that. You're allowed to do that. A moratorium is a pause, right? So it's a pause. It can have an adverse effect, obviously, on a project, but it's a pause up for 180 days, and that can be extended for another 180. Ordinance amendments, you could do that immediately, right? So you could say, you know what, we're gonna make a retroactive ordinance to say, just use a simple thing to have 50-foot setbacks there instead of 30. And we're gonna apply it to all pending applications. So you can do that, but you have to be explicit about that. And the reason sometimes it's not a good idea, right? Sometimes you may think, look, these guys are in, we're already reviewing it. So you may choose not to have retroactive clause, and you want to go forward. Final thing I'll say is, what you brought up is there is a new law that changed the presumption, all those presumptions I just talked about, as it relates to housing projects. Because, and rightly so, housing is a big issue in the state, and the legislature has been passing all kinds of housing laws, tweaking statutes here and there. And one of the statutes they tweaked was this retroactivity provision. And it says, essentially, once a application is in that has any housing, any one unit, they are essentially vested once their application is submitted and complete. And there are still provisions, our little municipal attorneys group that meets every other month. We talk about issues around statewide association. That's one of the ones we talked about last time. We're all trying to sort out, the language is not ideal. Happens in the legislative process. So there's a lot of questions with that language, how it's who decides if it's complete? Does there need to be a hearing? Does it apply? Could you override it or not? We're still digging into it, but it essentially sets a new proposition. You can get vested rights, if you will, if you have housing. Anyhow, so that's the other part that people are picking up on. It could be a commercial project, but you have a unit in there. So that's the part that we're people are sorting out, like, does it really mean that or not? It to be determined, but that is a new law, and it's only been effective for a short period of time, and I haven't seen it sort of applied yet. So,
Thank you.
This provision, if it's submitted in complete form, that's a very loosey standard. If somebody's going to mitigate that, to say, what is a complete form?
it would have to be some sort of determination of completeness, is the way I would look at it.
Right.
So that the planning board has determined it's complete, or if you have an ordinance, and I should know this, but sometimes staff have that role in some towns, but it has to have been, someone has decided, right? It's not later after the fact, was that complete or not? The board has to have decided, or the staff member has decided.
Well, we now make a motion
We have a motion. to say-
Well, that's right.
on every project.
So to his point, I wasn't gonna solve it here, but I think that maybe our point is where we do take a motion and say an application is complete. That's when if it's voted complete, then it can't go retroactive, you know.
But you can
at least
still,
look at that, right?
well, so that was my point about this, is you can't say this cannot be you cannot have retroactive provisions, because you don't have a charter. Every town meeting is different, right? So you could have an article before the next town meeting, and the town meeting says, we're gonna amend that, we're gonna make it retroactive. So you could have it today saying you cannot apply retroactive ordinances. You could write that, and it could be, the next meeting, you could vote that out through a moratorium that includes a retroactivity provision. Notwithstanding anything in any of our ordinances,
Regardless
this
of the
is, yeah,
state law,
that's right,
because it's more,
that's right. Yeah. So I would maybe not even address it. It is just a law. You, as a town meeting, could decide to have a retroactive moratorium. You could decide to have a retroactive ordinance provision if you wanted to. But you don't need to really address it here. It was more I wanted to point that out, that could happen. And then we want to get this right in terms of what you do want, the standard if you don't have retroactive, how you want that to read. I think you could do that. You could say, look, until it's changed, we are going to only apply new ordinance provisions to things that have not yet been found complete.
I believe,
And I think that's
over
what
the
you're
years,
saying
the way we've always
Yeah.
done it is we haven't applied it going forward, we haven't come out with retro. Other communities that have.
Yes, yeah. I only pointed out one specific waiver one. I'm gonna go through these bullets, and please stop me if questions at the end or throughout. On page 2-24, this is in the master plan development provisions. It's a waiver. It's 2.140-3. Specific waivers, it's called. And I'll read it. The planning board may approve a master plan development that meets the intent of the master plan intent section in the purpose section, but that deviates from strict compliance with the master plan development regulations from this section. Site plan submittal must include a clear description of the regulations to be waived or modified. So that's very broad. There could be things in here that I was trying to determine what exactly, and I haven't been part of this development, so I didn't know exactly what the master plan development was intended to do. I'm generally aware of them, which is that they generally apply to larger areas and you approve a general development scheme, if you will. But that gives full waiver authority to anything in that section, as long as you determine that the intent is there and the purpose is there. So that seemed pretty broad to me. Maybe you want to be a little more specific.
And that's 2.140.
Yeah. 0.3 A2.
Yep.
Yeah. I am going to point out the next one. I'll go slow so people can get to it. 4.60-3. That's on page 4-6. This is the affordable housing density. At least the way I understood it, it doesn't go far enough. So this, for those who haven't been following this closely, this was part of LD 2003, which requires municipalities to allow for affordable housing density bonuses if the development meets certain standards. You have the other ones. So there's affordability standards, and I double checked those. And so in other words, applicability and affordable housing standards, those are correct, but the density bonus is supposed to be 2.5 times the underlying density, not 60% of. So that comes right from the statute. So you want to take a look at that. Now, we have a lot of 2000. So that's in 4.60-0.3. It's called density bonus. So projects that meet this standard get 60% reduction in the minimum lot area per unit, but really the standard is 2.5 times the underlying density. Yeah. Prohibition on manufactured housing units. So you can't prohibit manufactured housing units. And in fact, the legislature just expanded that, or this session. So you already had to allow manufactured housing in any area where single-family housing was allowed. The legislature, and that was defined as modular homes. Particularly, there's two types of manufactured housing: modular homes and mobile homes, essentially. And so mobile homes have to be allowed generally in the community, but you could regulate those a little bit more. Modular homes have to be allowed everywhere single family. You can't say you can't. The legislature changed the mobile home, and that has to be allowed everywhere. So, but this was even written more broadly. You said manufactured housing generally, so that was already out of compliance. So you're going to want to take a look at that.
Those could still be, the design standards.
Yes, and I pointed
Those
that
would
out.
still apply, it's just the
Yep.
concept of.
That's right. So that just has to be, you can allow for design standards.
On design, I have a question on that. It can't be so broad as to turn it into something else per se. So a mobile home is a mobile home. On a frame set on a slab, so to require a foundation per se, then that would be reasonable.
That's right. Yeah, and mobile homes in particular, there's a provision, I don't have that statute with me, but it says you can regulate roof angles, I want to say, and something else. So there's two different areas you can regulate that. And then you can apply general design standards to the homes in general. So to the extent you have the downtown, awnings and some of these, like the Yarmouth one, gets very specific about how the windows have to be this far apart, but you can have those kind of design standards. Yeah, for manufactured housing. Some of these are very minor, like terminology, so I'm not going to get into that. I do want to talk about this 2/3 vote issue because that was unusual. Do you have that today, or is that a proposed new? What I'm talking about here is section 12.20.7. I didn't know if that was an existing deal, Mark.
I don't know.
So what the provision says is it's amendments to the zoning ordinance. And it says in the planning board must give its recommendation for amendments, but if the planning board votes to not recommend it, then it requires 2/3 vote at town meeting. And in my view, that's not permitted. I don't know if you already do that. So it's already, that was a question I had. I was just looking at the ReCode. The reason why is because that's similar to what I just talked about with retroactivity provisions. You don't have a charter. So you could have something like that in a charter, which is a law that continues beyond that annual town meeting. But
Where is that?
it's in 12.20.7, which is on
What we
page
vote on is recommend.
12.4.
Recommend that it shouldn't pass.
Right. And so 12.20.7 adoption, so it's talking about amendments to this ordinance.
Yeah.
Proposed amendments receiving a favorable majority vote of the planning board may be adopted by simple majority of the town meeting. Proposed amendments that do not receive a favorable majority vote may be adopted with a 2/3 supermajority at town meeting. And the law court has weighed in on that topic generally, which is you can't through an ordinance require beyond just majority vote at town meeting, because your town meeting gets to decide what it wants to do.
Yeah.
You could in a charter. So a charter is when you're creating your new constitution for your town, basically, that continues beyond an ordinance. You could, and the reason why I think of it this way, you can always amend an ordinance. You can always amend an ordinance with a majority vote. So the next town meeting, you could just amend that out. That's the idea behind it. So I would recommend taking that out and just say, the planning board does need to have a quick hearing and provide its recommendations for inclusion, for inclusion on the warrant. And people can vote the way they
And
want
the
to vote.
select board decides whether it makes it work.
That's right. The select board ultimately decides. That's right. So there's still a sort of stopgap there. If there's a reason not to advance something, unless of course there's a citizen petition, and those
And that's-
typically go
that's-
right
That doesn't. fit there.
outside.
That's separate.
Although citizen petitions, you still do need to have a public hearing, and you're still allowed to have an opinion on it if you want to. Yeah. So there's a couple exceptions, and I know your code officer pointed out the exceptions, and I looked at the exceptions are treated differently than waivers in here. So there's some exceptions, like the code, and they're typically given to the code officer. The code officer is allowed to provide an exception for various provisions, including, for example, just on the top of my head, I remember there was one pesticide, I want to say, or something like that. If you met a standard, but it was tied to a standard. So I was actually okay with some of the exceptions that were given to the code officer. They weren't zoning provisions. They were sort of different, but there were a couple that I did point out, and that's at the end of my list here. So one was very specific, that is just, in my view, was not allowed, and that's section 15.10.6. And that would allow a code officer to waive setbacks. And then going on about height, stories, number of stories. These are in your measurements, interestingly enough. There's a chapter just called measurements and how do you measure things and the standards for measurements. But it actually had these substantive provisions in there, including these exceptions / waiver authority. So I would take that out. And to the extent that it's allowed under the discussion we had earlier, I put it in the applicable section. Because you don't want to have to look at two different places. It's the other thing.
What? I just seem to recall, zoning board at some point had the ability to do administrative exceptions, and then that was eliminated.
Right. Yeah. So those are the rest of it. Looks like I don't know why the last one just says definition.
Yeah,
I guess I missed that. I got stuck in thought, and I'll come back to you on what I meant by that one. There's another definition of something I didn't like. So I'll have to get back to you on that. I apologize.
no,
Oh, I think I know what it was, and I deleted it, which I don't need to get into. It was the mobile home definitions. I was going back. So a mobile home is defined under this ordinance as a manufactured housing unit constructed prior to June 15th, 1976, which, but then you do have, and I was like, well, that's not correct. But then you have a second category, which you don't always see in these ordinances, called mobile home newer, which is basically mobile home today. That's what we consider today. That's actually prior to 1976 is an older mobile home of the ordinance. And you can regulate those things differently because they would have not been reviewed by the state manufactured housing board, for example, for safety and things like that. So anyway, I decided it was okay. And I should have taken that out because you differentiated it differently. You differentiated in a way that didn't sort of carry through the ordinance in a way that I didn't have a problem with. So I know that's pretty high level, but I thought it was worth having that conversation, particularly around the waiver and then some of these LD 2003 provisions. So
if you don't mind, anyone here have either questions or comments for?
The one thing that I want to put in the conversation is a very carefully worded comment by the chair of the zoning board of appeals.
Okay.
On ReCode. And I can't quite tell if some of your comments are square on it or not.
okay.
So I'm just gonna read it.
Yeah.
It's not enormously long, but it should variances be restricted to dimensional requirements. Otherwise, the Board of Appeals would have to evaluate building and architectural design criteria of Articles 2 and 8. The planning board can waive these requirements per section 12.30.3 and Article 8. It may be worthwhile to define waiver and variance criteria, which you have, for regulations, guidelines, and provisions, and which board should grant a waiver or variance based on different type of requirements.
Right.
So I think you have.
Yeah,
hit
that's
that.
consistent with my view.
Yeah, got it.
So I do think that, so variances are for dimensional standards typically, and not, almost always. There are a few exceptions or uses, which are, you're allowed to take that authority away from the zoning board, because a lot of towns don't like the idea of a use variance. So other than uses, they are typically dimensional standards. And then otherwise, I agree, the planning board probably should be given waiver authority in certain circumstances as it relates to design standards, because it's not everything fits in a neat box. You need to have some, some sort of ability to relax the standards if it's just going to not make the project work and everyone feels comfortable with it. not meeting the standard exactly. So there's nothing wrong with the waiver, the appropriate type of waivers. It's just always good to have some standards in there. But what it is, like, you know, what are they gonna apply when they're thinking about waivers? Just because I like it, it shouldn't be just because I like it, right? It should be because it's not feasible to the development or doesn't detract, or, you know, you could have, there's some standard language in other site plan review ordinances you could grab, because you see that sometimes. The board can waive this as long as they determine that safety is not, like on the traffic standards, for example, that safety is not gonna be sort of implicated in any way, things like that. So that there's an actual finding of fact as it relates to that waiver.
And one of the things you said earlier is to sort of set an outer limit.
Right.
And what needs to be done to meet that.
That's right.
Yeah.
And that would be on the dimensional side,
Yeah.
right? So in that case, it's not a waiver or a variance for that matter. It's the way, it's all in sort of terminology, how you frame it up, but what you're really saying is, let's use the height example. 60 feet is allowed, but only if these circumstances, right? What would be different is 40 feet are allowed, but the planning board may waive it, which is what it says today. The planning board may waive the 60-foot requirement if it chooses to.
Yeah.
And so that's a variance, and only the zoning board could do that.
So we do waivers today.
Yeah.
I think
Yep.
typically we do it for the right reasons, but my comment earlier was I just don't want to open up the door too much.
Right.
But that being said, do the consultants, you guys have any questions or comments?
Explanation. I only wish we could get continuing education credits for the legal treatise. I'm sorry?
Do you have your sound as the owl, Josh?
While he's tying them in.
Yeah.
I don't want to go very far down any path, but you mentioned earlier about conditional use, I guess. If you don't mind, I'd kind of like your comments and thoughts on conditional use.
Sure, and in fact, I'll remind myself, but I know that I had weighed in on some questions from your former planner about conditional use standards and that sort of thing, right? So conditional use.
Or just an overview.
Just an overview, yeah, so a conditional use is a type of use that actually is allowed in a district as long as you meet certain conditions. To differentiate it from a permitted use, which are just allowed as right. Right, again, you still have to meet your dimensional standard and things like that, or performance standards, but the conditional use is, this is allowed if you meet these standards. Those standards, and similar to what I was talking about before under waivers, have to be articulable. You need to know how you meet them, right? And so some standards have been struck down by the courts over the years, including a famous one next door in Brunswick that you learned in law school. When you give too much discretion to the board, because what you could end up doing is allowing discrimination and disparate treatment of different applicants, because people don't know how to meet the standard, right? So you can't say that it fits in the neighborhood is sort of one idea, right? Well, what does that mean, fits in the neighborhood? You've already decided it's allowed, so you shouldn't be able to say that in that case, a multi-family building doesn't fit in the neighborhood because you said it's a conditional use already. Instead, you should say, does it meet certain specific standards? So we went through that exercise with Julie, I think, and I provided some feedback and I suggested some things should come out, or she came up with something. I think you guys arrived at something fairly good. I haven't looked at that for some time.
I think that's part of what we're going to be reviewing again. So, yeah, there was a start on that.
Yeah.
And since you mentioned it, just thought I'd bring it up. That will be coming back around.
Okay, good. Yeah, no, happy to take a look at it. But there's a couple local sort of well-known cases on that, Cope versus Town of Brunswick and Waco versus Town of Yarmouth, that are sort of the standards in that area.
Did we get them?
Kirk, can you try to speak again?
Yes, can you hear me?
We're not.
We could always follow up.
Volume? Not-
I'd be happy to, if they submit some written questions or have a phone call, if you think that's helpful with staff, I could participate in a phone call or Zoom call with them. a separate offline.
One moment, will you test your speakers via Zoom? Do the audio test, I want to see if it's a new issue.
Hello? Anything? Test, test,
I can hear
test?
you, Kirk.
I can hear you.
We can hear you.
Oh, you can?
Yes, great.
So
Uh-huh.
any what you guys have?
No, thank you. Thank you. I thought that was a terrific explanation. Phil was kind enough to kind of give me a bit of a primer on the waiver question several months, if not years ago. And I think we partly bungled it and partly tried to push the envelope a little bit, knowing that we might get some pushback once he laid
That's
out.
right.
some-
Was that in Yarmouth? Was that in Yarmouth?
No, that was,
Or was that here?
yeah.
Oh, it was here.
It,
Okay.
it was here.
Oh, yeah, I forgot we had spoken before. Yeah.
Yeah.
Okay.
No, the review is, I think, spot on, from our standpoint. I appreciate how professional and frankly, how gentle you were in reviewing some of our provisions and in presenting your findings. The only thing I think I might quarrel with is the density bonus thing. I
Okay.
understand the reduction, the 60% reduction in the minimum lot area per unit, which is our measure of density, does result in a over a at least the required state minimum density bonus. For example, a 60% reduction in a half-acre minimum lot size takes the minimum lot size down to 8,000 square feet, which does result in the 2.5 time.
If the math works.
The-
I had never
think
seen
it-
it expressed as a 60% before,
Yeah.
but if you're just gonna want to make sure that math works because there will be people out there looking to challenge that.
Understood. And I will
Three.
maybe send staff my calculations and you could just lay eyes on it and see if you agree. But I think it's a math question. It is expressed a little differently.
It is, yeah.
I fully admit than you might expect, given the nature of the law, but I do think it's in compliance.
Okay, well, I'm happy to take a look at that again.
Yeah, thank you.
I think there's also a possible chance that potentially we'd want to do more than that. I know the select board has been really interested in affordable housing, so potentially we need to have that discussion. That 60% and just meeting it is what we as a town want to do, or maybe it's a higher percentage.
Yeah, you can go beyond.
Just to put that out there, that we could, if we're worried about the math, maybe we just go a little higher or something.
Yep, and you could go higher in different districts even. Just the 2.5%, 2.5 times is townwide. Well, as long as it meets the other standards, like you have to be in a growth area and you have
Yeah. Okay, great.
water sewer requirements. Yeah.
Anything else? Why did you have anything more?
Yeah, jump up and use a microphone. So Kirk and in particular Leslie, figuring out where we go from here. I think looking at the process so far, we've had now a couple drafts and we've had some of our developers have been very generous about coming in and giving input and things. And some of their concerns when they get raised, some of the solutions have been to try to push waiverability. Given on what you heard tonight from Phil, are there things that maybe you want to float to Phil or ideas or suggestions that you think we can get into place? I don't think we want to do through the entire town have certain building materials required for houses, like we were trying to do with the form-based code part, because we'd have a mutiny. So there's probably some things we can't move to site review, and I'm not a planner, I don't play one on TV or an expert in form-based code. But are there things that are worthwhile that you could ask Phil, or some discussion that would give us a sense of where we go from here, or how we can make this work?
I will say that getting more specific, we can certainly do. And I think that we've got enough, we got such great feedback during the public meetings. Can you hear me okay? We got such great feedback that I think that we can sort of tailor that specificity to the things that people were concerned about. What I'm concerned about is and again, I haven't had time to really take a look at this in a lot of detail, and I think we'll need to come back and have some more conversations with staff. But my concern is that the building design regulations and so Article 8 are specific to Thompson Center, and any specific waivers that we might define there or anything, I mean, it really, those are the kinds of things we would love to be able to take to planning board. And I don't think, it doesn't sound like the ZBA wants to even review that kind of thing, which we probably wouldn't want them to either. So I think figuring that out is going to be probably our toughest challenge. Because we can't move those to site plan review because they're specific to Thompson Center. Could it be that it's specific to, I mean, I'm trying to kind of, move around. If it's not specific to zones, could it be specific to an area as opposed to specific zones? Like, could we define an overlay of, is that zones, or could we define a geographic area that the site plan review standards apply to? Or is that still considered
You
zones?
can, really the issue is the dimensional standards. That's the bigger issue. So it's defining what you're asking them to waive is in some ways more important than the fact that it's in a zone. Because you'll have specific form-based areas, like I was saying, in different towns, and that's okay. But the variances are tied to dimensional standards. So setback, height, lot size, density, things like that.
Mhm.
But in terms of, I'm okay with the idea, and not just me, the law I think is okay with the idea of having waivers for building design. That's not a dimensional standard, buffering, lighting, those kind of things, traffic, parking kind of things.
Percentage of glass.
Right, percentage of glass.
Yeah. All right.
Those are not dimensional standards. Yeah.
No
Okay.
problem.
So sorry, just to follow up on that. So if there are zone-specific standards, but they're not those ones like height and setbacks.
Right.
Because the planning board can waive those even though they're.
Right, because if you look at the variance statute, and I could give that to you, it's actually, the variance provisions in here are correct. So I double checked them. You'll see it deals with dimensional standards.
Okay, great.
That's only the zoning board can waive those.
Okay.
So vary those. Yeah.
Okay.
And actually, they're very specific here. Lot area, width, frontage, setbacks, coverage, height. I didn't pick this up, but I heard you say this. I didn't realize G and H are design regulations and Thompson Center building regulations. So I think you could take those out. And it sounds like zoning board chair has no interest in doing that either. So you treat those as almost like site plan or site plan standards, right? Or site plan standards.
So,
Yeah.
Yeah.
So it sounds like this can all work in the zoning ordinance, but at some point, it sounds like the zoning ordinance also wants to direct the site plan. To do that, it would have to be a town-wide standard, or I just heard possibly an overlay, make the center zones an overlay.
Yeah, I'm not sure you need that though. I don't
No,
know if it's sort of applicative.
So, the zoning ordinance, could it be as simple as you meet this basic set of whatever it is, right? And then, but all projects also have to go through site plan. Meaning, and then whatever standards can't be addressed through zoning will be addressed in the site plan.
Yeah.
And waivability.
You could do that. That's how you do it today.
Yeah.
That's how you do it today.
So you keep the base set in the zoning, and anything that you can tie parameters to, like,
Right.
you can have this exception, I suppose, if you meet X, Y, and Z.
Right.
And anything beyond that would just have to be moved, directed to through this, I guess, right?
Right. And you could, it's hard to conceptualize. I know it takes a lot of time to put this thing together, but you could have a set of space and bulk / dimensional standards, which in form-based code looks different, as you know, but it's same idea. And then you could have the design standards, or design and performance standards, which are different. Those are different types of things.
Yeah.
And you have that, it just all mixed together.
Yeah.
And I understand why you'd want to do that, because you're looking at a development and you're going through and you're applying everything, but there is this underlying issue about waiver and variance authority.
Yeah.
So Tom, just. So what your suggestion of, and maybe I wouldn't follow this. It would create some type of form-based overlay district.
Well, that's what I just
In the
heard.
village center or whatever?
But maybe you don't need to do that. Once you get the site plan, it has to be town,
Right, site plan or town-wide standards.
Yeah,
It's
so-
really applied.
which would be the problem.
But what I'm hearing is that we can have things in the zoning code that are not necessarily that stipulation, that only the ZBA can give a variance for, that are zone specific, so we can keep the Thompson Center zones, work on the stuff around
Yeah.
waivers for things that are only variance, eligible. So, we can have the center zones, they can have the, design requirements in the zoning code, so those are for those zones. And that the planning board can waive those within the zoning code.
The performance type standards.
Yeah,
design type
like the
standards. Just make
design
it clear.
standards. Yeah, that's what I'm kind of, like
Yeah.
specifically the design
Yeah.
ones is what I'm getting at.
Right.
So like, we can't have like the planning board give a waiver for your height. We've
No.
discussed that. But like, in the next section, we can say, this zone has to have these design standards and these are waivable by the planning board.
Right, under these circumstances, like, or yes.
Yes, give some circumstances, of course, yeah.
Because those aren't, just keep coming back to it in your mind, are they dimensional standards?
Yes,
Yeah.
yeah,
But the waiver, the reasons for a waiver have to be specifically spelled out.
Yeah, it's very good to have some kind of standard to apply.
Right.
Instead of just
You
may
can't
waive.
just have the old famous Potter Stewart.
Yeah.
Kind of, I can't define pornography, but I know what it is.
Exactly, yeah, you shouldn't have that.
We shouldn't have that.
Where are you going with this?
good point, Larry.
So Tom,
Yeah, I
People
think
been
the
lost
waiver
over
would just
that.
be a set of options.
I'm sorry?
Waiver, look at it as a set of options, so if you do this, you meet this, if you can meet these additional criteria, you can do this.
But you're gonna go from 60% glass to 50% glass, we need to have some sort of standard.
Right.
To be able to say why we're waiving this
Yeah.
requirement to have 60% glass.
Right, and it could be just one standard that's applicable to all of that kind of waiver. Like,
Mhm.
and again, I should have looked at it before, you may already have something like that, I don't know
Yeah.
if you do, in your current waiver authority.
Yeah.
But if not, there are a lot of examples out there, we can pull from other towns to say,
Lovely.
may waive these site plan standards or these performance standards if the board finds that,
Mhm.
So there's just something you're tying to. It's a pressure relief valve, really, for everyone.
It doesn't fit.
Yeah. Right. You don't like the way it looks here.
That can't be a standard.
Right.
Stay away from the pros.
Yeah. And that's-
So-
that was a long time ago. but-
Someone else has
Yeah,
something?
I got a question. So you were reviewing the April,
That's the one I was giving,
Revision.
yeah.
so since that time, I know Tom has gone through, and he cited a lot of the similar things that you noted, and some other provisions where he said, well, wait a minute, no, the code enforcement,
Yeah.
shouldn't be left to the decision, code enforcement, it should be
Yeah.
defined one way or the other by, and different provisions, the, zoning board weighed in with a couple of different comments. I guess my question is, merging some of these overlaps and reviewing, so we're not saying, all right, well, if one of Tom's comments about a particular section now conflict with what you just
Yeah.
said.
I don't think it will. I actually had the benefit of Tom's list. It was forwarded to me.
And unfortunately, I think what this means is we're gonna need a third draft.
I think that's where I was
So-
going with that.
Yeah,
And I think we have one more step that needs to happen before the third draft, in that Andy Sturgeon and Kurt Neufeld and Chris Belanger have been working on our test cases, because we've been talking about for a while to have a couple of the developers work through under the new code and see how if there's unintended consequences we're not expecting. So what I envision is that happens, which I think they're gonna be ready to maybe schedule sometime as soon as November. And then we're gonna need to work with Kirk and Leslie to figure out the next steps, to come up with a third draft. That's gonna be able to incorporate Tom's comments, Bill's comments, what we learned from that, the public comments that we received. So I think we're gonna, unfortunately, probably not gonna be making it to this May's town meeting, because we need to get this third draft done and then go back out and start having hearings and workshops and stuff like that.
Thanks, Ken.
Yeah.
Anything else, sir?
I have nothing else. No.
All right, unless there's anything else, I guess.
Should I say something, Kirk and Leslie?
You're not gonna let me adjourn?
Not quite yet. So Kirk and Leslie, we'll reach out to you and schedule a time to set up and figure out the next steps to come up, best way to come up with the next draft and things.
Yeah, we look forward to it.
I have one thing, I'm so sorry. Phil, you already talked about sending me some stuff, but I was really interested in when you mentioned standard language for other site plan ordinances.
Okay.
I would love to see some of that
Okay.
if you have it.
If you wouldn't mind sending me an email.
Yes, absolutely.
When you get to the office tomorrow, and
Yep.
they'll team me up and respond to you.
Perfect.
Yeah.
Before I adjourn, thank you very much.
Thanks for having me.
Thank you.
Thank you.
Thank you, Phil.
Thanks.
Thank you.